Greetings from the ICO, and thank you for inviting us to take part in this event today. Many congratulations for the progress that you've made so far in implementing freedom of information in the Philippines. We know from our experience that this is a very challenging task, but one that delivers real value and significance to citizens. Ensuring greater access to information builds trust and confidence and enables members of the public to hold organisations to account for their decisions. Today, we're hoping to provide some brief insights into the implementation of FOI from the UK regulator's perspective, starting with a review of how our legislation developed and looking at some of the initial challenges we faced. We'll then give some brief details of how our legislation has evolved over time as it has become well embedded in the UK. And finally, we'll look at the current issues and opportunities that we are starting to see and address 12 years after the right of access commenced. So where does FOI come from in the UK? Back in 1997, the UK had an open government code that was overseen by the Parliamentary and Health Ombudsman, and it applied to central government bodies, and decisions that they made in respect of complaints resulted in just recommendations rather than any legally binding decisions. The Labour manifesto pledged to implement FOI legislation in the UK, and our Act was eventually passed in November 2000. Separate regimes were established for environmental information to implement a directive that stemmed itself from the Aarhus International Convention on Access to such environmental information. As you can see from this slide, there was a different commencement order each year from the passage of the Act until the right of access took effect on the 1st of January 2005. So it is not a quick business implementing this type of legislation. Prior to the obligation to answer requests coming into force in 2005, efforts had focused on developing and issuing codes of practice under Section 45, which dealt with request handling, and Section 46, which dealt with records management, and on repealing and amending legislation prohibiting the disclosure of information. This work was led by the ICO and the National Archives in the UK. Focus then shifted to proactive disclosure obligations and the development of publication schemes. These are documents that set out what public bodies are required to proactively make available to citizens. And then on the 1st of January 2005, a big bang approach to the requests with all public authorities, of which there are 100,000 approximately in the UK, obliged to respond to requests for information. During this implementation stage, key issues included consideration of budget, training, promotion. And as I mentioned before, records management came up. The government's white paper had included a commitment to impose obligations on authorities to improve records management in line with best practice guidance. And this was eventually operationalised in the form of a goal to implement government-wide electronic records management by 2004, and subsequently the inclusion of Section 46 in FOIA, which required the government to develop a code of practice for records management. Other issues included information technology developments and monitoring of public bodies. In brief, the UK legislation includes proactive publication obligations for both FOI and EIR, as I've just mentioned, a right to know whether information is held, and then to have that information communicated subject to a cost limit and a number of exemptions. Notably, the UK legislation includes a wide definition of information. It applies to information recorded in any form. There's no requirement that the requester is a UK citizen, and therefore anyone in the world can make a request for information. Under the FOIA, the request must be in writing, but under EIR, a verbal request is also valid, and this presents its own challenges. Across the UK, the respective commissioners have powers to make legally binding decisions. In Scotland, decisions are appealable on a point of law, and in the rest of the UK, appeals are to the first tier tribunal, which is free to access and involves a full merits review. A commissioner's role can be broken down into three key areas. She's an educator and is required to promote best practice and provide advice about how to comply with FOI legislation. This includes an obligation to approve model publication schemes. She's responsible for adjudicating on complaints from members of the public, and she's responsible for ensuring compliance with the broader regulatory framework by the use of her enforcement and prosecution powers. Section 77 of our FOI Act makes it a criminal offence to deliberately destroy, hide or alter requested information to prevent its release. So as I mentioned previously, publication schemes were initially a key area of focus. This was the push element of our regime and aimed at making as much information as possible available in key areas. And the hope was that this would mitigate the level of requests received and would demonstrate that public authorities were willing to be transparent about their actions and decisions and would embrace openness with citizens. Initially, the ICO had a team of staff working on publication schemes, engaging with stakeholders in each of the relevant sectors to help inform the content of the scheme. This slide gives a brief overview of how our requests and appeals operate. You'll note that when a request is refused, applicants are initially required to complain directly to the authority and ask it to review its handling of the case. This is an important step that allows the organisation to resolve problems without involving the regulator. We've found internal reviews to be helpful, but also an area in which public authorities struggle to be sufficiently timely. Our advice is that in all but the most complex cases, internal reviews should be completed within 40 working days. Once a complaint is received, we will review the case and make a decision about it that can subsequently be appealed to the Information Tribunal for a full merits review. Beyond the tribunal, parties can appeal on a point of law right up to the Supreme Court and the Court of Justice of the European Union, and we've had cases go right to the top in our 12 years of operation. So, operationalizing FOI. The ICO developed a regulatory action policy for FOI, which set out for those that we regulate how we would approach our responsibilities, and we published this so it was readily available to public authorities and citizens alike. Initially, many of our cases involved new points of policy interpretation, which took time to resolve. And there was a wide range of cases, many involving high-profile and controversial matters, but also a significant number that were very much more particular to the individuals concerned. These quite often involve local authorities and long-standing points of dispute, for example, around planning permission issues on individual properties. It quickly became clear that a very thorough and well-reasoned decision notice would be required from the ICO to withstand the judicial scrutiny that comes from being able to issue legally binding decisions with the right of appeal. We also found that many public authorities had complex internal processes, and that this, combined with the fact that many of the issues were new and novel and potentially precedent-setting, led to delays at all stages. Where third-party consultation was required, for example, where commercial interests were at stake, consultation was patchy. This led to problems at appeal stage when trying to defend some of the arguments that were being put forward to justify withholding the information. Another mechanism that was put in place by central government was to establish a central clearinghouse in September 2005, and this was to ensure consistent application of the three main access regimes in the UK, the Data Protection Act, Freedom of Information Act, and the Environmental Information Regulations. And it was especially relevant where the same request was filed to multiple agencies in ensuring a consistent approach. The Central Clearinghouse was subsequently criticised by some applicants for the delays that were seen by some as beneficial just to the public bodies involved. However, others saw it as a really useful source of advice, particularly where they lacked their own resource to develop comprehensive expertise in FOI. Overall, the ICO found that within a relatively short period of time, all of these complexities meant that we built up a significant backlog of cases. So there are three areas in which the ICO experienced particular challenges in the initial phase post-implementation. Triaging cases and ensuring eligibility. We found that cases came to us in various states of readiness. We often found that applicants had not actually exhausted all of the relevant stages of the process, or that they or the public authority involved hadn't got sufficient written evidence of how they'd handled the case or the complaint up to that point. In the very early days, we also found that people made requests prior to the implementation date, meaning that their complaints were and their requests were in fact ineligible for consideration. So careful managing of individuals' expectations about how they submit requests is key. Due to our backlogs, it took us some time to identify these problems, which then led to dissatisfaction on the part of customers. We found that there was a lack of sufficient training for staff in public authorities and the ICO alike, given the level of detail required in some of the legal decisions. For our own staff, it was evident that this also extended to some of the investigative techniques required, and so we did bring online technical training. We also lacked basic processes for case handling, including accessing and storing the disputed information, which we quickly resolved. We also found it was difficult to manage the considerable amount of new knowledge internally, as effectively as we needed to. And finally, it became evident rapidly that we would require additional legal specialist resource in terms of advocates and barristers to deal with appeals that needed to be processed alongside the public authority at the appeal stage. In terms of specific policy issues that arose during the initial phases, there were 3 areas to particularly pull out. Despite a clear and broad definition of what constituted recorded information within our legislation, that there remained questions to be answered about how this would be interpreted in practice. We had a precedent-setting case which involved a decision as to whether a working economic model in the form of a functioning Excel spreadsheet, including the relevant formulae, all constituted recorded information within the scope of a complaint, and we found that it did. Information about government policy making proved particularly contentious, with strong arguments being made about the chilling effect of releasing information about policy decisions on future policy making processes. Extensive arguments were also made about the impact of disclosure on record keeping, and we eventually commissioned external specialist research to assist with our interpretation of the exemptions in order to support the decisions we were making. Over a significant period, government expressed concern and threatened the use of their ministerial veto, though they didn't actually use it in many instances. As a regulator with 2 hats, we experienced a lot of cases that tested the personal data exemption, and 3 particular issues arose. The first was around individuals who requested information that encompassed their own material and wider information, and we quickly had to establish and make clear where the lines were drawn between the 2 categories. We established a position that meant we could transfer cases which were initially identified as being freedom of information requests, so that to the extent they covered the information about the individual, they could be processed under the more appropriate Data Protection Act, and we'd ask public authorities to reconsider their responses accordingly. Secondly, we found that many cases involve requests for details of pay and rewards received by ministers and civil servants. The former were the subject of significant press attention, and requests exposed the fact that there seemed to be a lack of oversight in the expenses system for members of Parliament. This ultimately ended up with greater scrutiny being built into the system. Related to this was detail about the pay of public sector workers, and the ICO developed a policy position regarding disclosure of salary details, opting for disclosure in pay bands rather than specific amounts for most middle-ranking and outward-facing officials, with more specific details being disclosed for the most senior within an organisation. And the third area was around meta requests, and this is where individuals ask the ICO for the file that relates to the way that their complaint is being processed. And again, systems for these types of requests and dealing with the extent to which these constituted requests for personal data under the Data Protection Act were quickly established to ensure that no information was inappropriately disclosed publicly, nor was any disputed information inadvertently released to any applicant. Decisions about what were in the public interest was also contentious. We had to reiterate that disclosure was to the world at large, and we developed policy positions that the public interest didn't amount to private interests often being pursued by individuals. This has been subsequently further developed, and we've found that it's necessary to include individual interest to some degree where they can be linked to a broader public interest argument. This slide summarises some of the strategic challenges we experienced beyond what I've already spoken about. To respond to some of the challenges, the ICO did a number of things. It established dedicated teams to create external guidance for public bodies based on our decisions and those of the relevant appeal courts. The Information Tribunal significantly shaped the interpretation of the legislation, and the ICO established a policy department to develop lines to take, drawing heavily on those judicial decisions and expanding them. We also established a knowledge base for ICO staff so that we could share information about decisions we had made to improve consistency. And we subsequently published this so that it was available to public authorities responding to requests so they could understand our position. A number of staff with delegated authority to sign off formal decision notices was also expanded to try to cope with the level of case we were receiving and increase throughput. And we also brought on stream additional legal resource to manage the appeals process. 3 years after implementation in 2008, we'd been through a steep learning curve, but FOI was well established. Public appetite was continuing to grow. Public sector bodies continued to struggle with limited resources, but their own understanding of the legislation was improving. Reviews of the burden and whether a fee should be brought in also started to be mooted. This was mirrored by experiences in Ireland, which actually saw a fee brought in following a few years of implementation of their own legislation, and that in itself dramatically reduced the number of requests. In the UK, this was eventually decided to be unnecessary. Suggestions also that we may need to limit the number of requests that one person could submit were also eventually rejected. Following a period of significant focus on requests to public authorities, we've decided to take a further look at proactive dissemination of information and carried out a review of publication schemes, introducing definition documents which set out further detail about the information we expected bodies to make available. The use of definition documents also meant that there was greater flexibility to add and review categories going forward. We also encouraged greater use of disclosure logs by public authorities to show what they had actually released in relation to previous requests to avoid repeats. We also saw a development in innovation and technology so that websites such as What Do They Know, which is a public system for making requests and receiving responses, helped in making more information generally available. We also found that in certain sectors, public policy decisions improved the proactive dissemination of information. So in local government, requirements were brought in to make details of public contracts awarded that were over the value of £500 available, and we used this and dovetailed it with the proactive dissemination requirements of publication schemes. What you can see here is that the fact that our Act did not stop at its development and completion in 2005. Subsequent to that, after almost a decade, we've seen a number of amendments to the law. Examples include a restriction on the exemption that relates to communications of the royal family to make this an absolute exemption so that it is not subject to a public interest test. We've seen the reach of the Act extended to include different forms of school, academy schools, and to further bodies such as the Association of Chief Police Officers. There's a general pattern of extension of the right of access across a number of bodies. Now, to give you a few figures, you can see how request levels have evolved over time, with a dip initially and then a relatively sustained period of growth over a number of years. Between 2005 and 2010, there were 693,650 requests to local government bodies, as opposed to 220,000 to central government. As you can see, this amounts to a sustained higher level of requests to local bodies as opposed to central government, which perhaps reflects the fact that people are often most interested to find out information about things that have a very direct and local effect on them. This slide just indicates the level of complaints that the ICO currently receives, and over time this has grown, so that between 2015-16 and 2016-17, we've seen an overall increase of 252 cases, with 5,433 cases received in 2016-17. Again, you can see from this image that the breakdown of complaints across sectors varies considerably, but there's a definite skew towards local government. We've also seen developments over time in our complaints and investigation process as the numbers have risen and our experience has grown. We've developed and refined our complaint handling to include clearer stages, including informal resolution. Whilst we find that that is a valuable element, we did decide that we needed to put limits around it in order that cases did not go on for extended periods of time. Nevertheless, seeking to address the concerns of both parties and to reach an informal agreement remains an important part of our case handling. Another area to note is the importance of clarifying the scope of a case. This is key from the outset to ensuring that both parties are seeking to address the same issues. Our formal approach to decision notices has also evolved. We now only include technical breaches if the complainant has specifically requested that we do, or we identify that there is a particular issue. We don't include this detail as a matter of course. We've also learned that we need to be extremely clear about possible remedial steps so there is no doubt as to what we are asking a public authority to do in order to comply, and that we can follow it up if necessary where they don't do as they've been told. Other matters is also a section that we use in decision notices where we can't make a formal decision, such as details about the quality of internal reviews, records management, or engagement with us as a regulatory authority. In addition to refining our complaint handling processes and reviewing proactive publication periodically, the ICO has also developed its monitoring of public bodies on systemic issues. We monitor the timeliness of request handling by public bodies and seek to improve the overall performance of public authorities. We focus on repeated or serious infringements and poor performance. A general rule of thumb is that 4 to 8 complaints of delay in 6 months, or where the public authority published stats, less than 85% are responded to within appropriate timescales. We will then monitor more formally. Monitoring takes place over a 3-month period, and we consider whether further action is necessary in the form of our undertaking powers or enforcement notice to try to resolve the problem areas. And we aim to be proportionate and take into account any reasons that the authority has given us for their performance in this regard. Each team uses intelligence gathered from casework to encourage good or better information rights handling within the organisation. No specific procedures have been developed as to how they should do this. It's done on a case-by-case basis. We point out areas where we've identified issues in the request handling and provide appropriate guidance. And we can invite the public authority to come in for a meeting to discuss its performance and in order to provide advice. Generally, we ask the public authority to review its procedures and its training, or to produce an action plan of how they're going to improve. And overall, our focus is on ensuring that the public authority's request handling is in line with the purposes of the legislation, promoting openness, increasing accountability, and results in better decision making, and increases public involvement in the issues of the day, and the aim with a counter aim of reducing the number of complaints that come to the ICO, thus demonstrating that the PA is complying with the legislation. There have been a number of reviews of the legislation since it commenced. Most recently, the Burns Commission in 2005 looked into the operation and effectiveness of the law. It made a number of recommendations, but fundamentally it found that despite claims of excessive burden on public authorities and impact on government policy making, in fact the Act was working well. Key recommendations and findings were that it rejected a suggestion that fees for the requests to public bodies should be introduced. It recommended a narrower cabinet veto that should be used directly after an Information Commissioner decision rather than at later stages of an appeal, which we had seen in previous experience. It also recommended that additional good practice guidance be made available, particularly in relation to the handling of vexatious requests. Changes to the Section 45 Code are now being made in response to the recommendations. And so, current and future challenges for the ICO. As I mentioned, there are changes going through to the Section 45 Code to implement recommendations from the Burns Commission, which we are being consulted on. We're implementing changes to our data protection framework, and as a result, we'll be updating and reviewing our policies and guidance on the interface with FOI. In some specific areas, we're looking again at proactive publication obligations. There seemed to be an international appetite to look again at this area, evidenced at the International FOI conference that we co-hosted with Scottish counterparts a couple of months ago. In line with our international strategy, we're also building our work globally and sharing best practice with other authorities through events such as this one today. We're looking at the impact of new technology on information rights and specifically on access to information and their implications. Systems such as Yammer and Slack, which are starting to be used within public bodies across the UK. We're also developing a report to Parliament on the need to consider further extensions of FOI to cover private sector bodies that are used to deliver public sector services in areas such as social housing and general contracts. The Commissioner has also gone on record about her desire to further explore the duty to document, and that is something that we'll be picking up soon. Thank you very much for your time.